Thank you.
Our next presentation is titled Legislating the Soldier Vote. And we are still on time. How about that? Rebecca Rubinstein has served as an election judge in Ramsey County for nearly 20 years. While assembling a database of Civil War soldiers' burial sites, she became interested in Civil War era election law. She also worked in 2015 as a research assistant for the production of Civil War Homecoming, A View from Minnesota on the War and Its Aftermath, a co-sponsored production by the Minnesota Historical Society and Minnesota Public Radio. Rebecca.
Thank you, Steve. Many Minnesotans know that, can you hear me? I'm good? Okay. Many Minnesotans know that this state volunteered the first regiments for the Union in the Civil War. But every Minnesotan should know that our state invented the mail-in absentee ballot to allow these soldiers to vote. This revolutionary law extended to soldiers a means of voting that most citizens would not share until the 20th century. The law provided for uniform government-issued ballots, secrecy envelopes in which to place the ballots, and oaths attesting to the validity of the vote, witnesses to observe the voting process, and prepaid postage to send the ballot home. All elements we recognize as integral to absentee voting in this country. There were even provisions for allowing non-registered soldiers to register and vote simultaneously. During the legislative session in 1860, Minnesota passed major election reform. One key element of this law was a statewide system of voter registration. These reforms took effect at the election later that year. Spring of 1861 saw the legislative session end right before the outbreak of the Civil War, in an off year for national elections. As the war began in April, few citizens, not even Governor Alexander Ramsey, believed the conflict would last long. Our soldiers enlisted for 3 months, then 6, but few people expected service to extend past the autumn. When state and local elections rolled around in October of 1861, many people held the view that soldiers enlisted in service to the government willingly and knowingly gave up their right to vote while in service and away from home. Other government officers, including legislators and judges in many states, made this same sacrifice in the name of fulfilling their civic duty. One widespread view held that soldiers in particular should not vote at all because military service by its nature deprived them of their free will, an element vital to open democratic elections. In Minnesota, one officer, Reverend Thomas Inman, Captain, Company D of the 4th Minnesota Infantry, a Baptist minister in Stearns County, believed he could serve his country both as a soldier and as an elector. He insisted on voting before traveling from St. Cloud to Fort Snelling for induction. The polls opened early to accommodate him and his fellow soldiers. When the election for Stearns County Treasurer was contested in the case of Tenvord versus Proctor, the court ruled that opening the polls early violated election law and that the soldiers should have been denied the right to vote. While Captain Inman's case garnered little attention outside of St. Cloud, the idea of soldiers voting gained traction in the spring of 1862, driven by several factors. First and foremost, the war not only continued, it intensified. This required a sharp increase in the number of troops volunteering for service. Enlistments climbed sharply. Second, the autumn congressional election became a referendum on the war. Both anti-war Democrats and pro-union Republicans believed the soldiers' sentiments matched their own. In Minnesota, the 6th through the 10th regiments entered service that summer. With voting limited to males over 21, anywhere from a quarter to a third of our voting population found itself scattered across the country away from their polling districts. Minnesota's Constitution, Article 7, Section 3, stated that for the purpose of voting, no person shall be deemed to have lost a residence by reason of his absence while employed in the service of the United States. So soldiers had the right to vote in their home precinct, regardless of their location on election day. A slightly different situation existed for soldiers in Pennsylvania. At the start of the war, only Pennsylvania had a state law permitting soldiers to vote while away from home in military service. A relic of the War of 1812, the law allowed regiments to appoint officers as election judges, cast ballots, and transmit the results back home. Soldiers used this law in the fall of 1861 to exercise their elective franchise. The contested election results arrived at the Pennsylvania Supreme Court in the case of Chase versus Miller. Justice George Woodward's decision, delivered in May of 1862, became the seminal case on soldier voting law during the Civil War. The Pennsylvania case hinged on both the system of voting provided to soldiers and a new state constitution adopted between the War of 1812 and the Civil War. The law permitted soldiers to erect a ballot box wherever they happened to be stationed, as long as they were far enough away from home to make the journey impractical, if not impossible. The new Constitution, written in 1838, stated that electors had to vote in the district in which they resided. That's a direct quote, in the district in which they resided. Justice Woodward, having worked on the committee which revised the Constitution, insisted the wording meant that no votes could be offered by any individuals who were not physically within the boundaries of their home precinct at the time they offered their votes. He stated further that having military personnel oversee elections, quote, would be to confound the first principles of the government, unquote. Meanwhile, in Minnesota, the legislative session of 1862 ended in March with no proposed bills providing for soldiers to vote while away from home. One paper suggested that such ideas floated around the Capitol, but nothing appears in the legislative record. By the summer of 1862, as the additional 5 regiments of soldiers entered service, the need for action felt acute. Governor Ramsey called a special session of the legislature, scheduled for September, specifically to address the need for a soldier voting law. Of course, by the time this legislature actually met, most people's attention had shifted to Western Minnesota and the hostilities now known as the U.S.-Dakota War of 1862. While this dramatic development garnered the lion's share of the legislature's attention in the special session, the primary reason for and first order of business at the session was the soldier voting law. Notably, in April of 1861, after the outbreak of the Civil War, according to the St. Paul Daily Press on February 27, 1862, Governor Ramsey, unlike many governors in the Union, declined to call a special session of the legislature. The paper applauded his belief that the $20,000 required to fund the session was not a wise use of tax money. Passing the soldier voting bill in 1862, however, did meet this standard for both the governor and for the press. In this respect, Minnesota was not alone. Iowa and Wisconsin also called special sessions of their legislatures that fall to enact soldier voting laws. Rather, what distinguished Minnesota was both the innovative method of voting and the utter lack of controversy it engendered. Understanding the revolutionary nature of Minnesota's soldier voting law requires a little background in how Americans voted in the first half of the 19th century. For starters, the US Constitution says nothing about voting methods or procedures, leaving a patchwork of laws enacted by states. No state offered government-issued ballots. Individual parties printed tickets, usually in their respective newspapers, which voters cut out and brought to the polls. This presented problems for many soldiers, who may have had a ballot box set up for their regiment in the style of Pennsylvania's voting law, but little access to newspapers of any kind, much less one that matched their political views. Minnesota's law provided for ballots issued by the state, ensuring soldiers could vote in all the contested races for the candidates who matched their political views. There were no secret ballots. While many states had switched from voice votes to public meetings, the Australian voting system, which included standard ballots and voter privacy, did not find general acceptance in the United States until the 1890s. This meant a voter's ballot could be viewed, numbered, color-coded, announced, strung up, and known by all present at the poll. For most soldiers wishing to vote, this could be a risky proposition. Having views different from the commanding officer, let alone the commander-in-chief, risked retaliation in the form of furloughs, denied supplies, or even being sent to the front lines. Minnesota offered soldiers a secret ballot, providing cover for those holding dissenting views. Also, in the first half of the 19th century, states eliminated the property requirement for voting. This simultaneously extended the franchise across the economic spectrum and invested election judges with the power to decide who was and was not entitled to vote. Transporting this practice into the field, according to the Pennsylvania model, assumed most regiments had volunteers from a particular county or geographic area, and soldiers knew each other's eligibility. However, David Collins of Wayne State University noted that the ethos of caring more about fellow soldiers in the field than about election laws led to lax enforcement of voting qualifications. Minnesota's law removed this burden from the backs of soldiers and left it at home with precinct officials. As the ballots arrived through the mail, election judges used local knowledge of the soldier's residence, age, and service to verify voter qualifications. Fortunately, Minnesota had a registration law in effect for a year before the soldier voting bill passed. So even these judges relied less on personal knowledge and more on the previous year's poll to determine elector eligibility. This also addressed Justice Woodward's concern about maintaining civilian oversight of the voting process. Justice Woodward's decision stated further, quote, "The ballot cannot be sent by mail or express, nor can it be cast outside of all of Pennsylvania districts and certified into the county where the voter has his domicile," unquote. Yet Minnesota constructed a law doing exactly that. Since Pennsylvania did not have a statewide voter registration system, they had no way to identify a soldier's residence in the precinct receiving the ballot. More important to this alternative approach, perhaps, is the growth of and faith in the Postal Service. On a state level, Minnesota law deemed Postal Service essential to municipal existence. Being a young state with population centers scattered along rivers, facilitated deliveries in a timely manner. At the national and international level, all mail destined for British North America, including territory controlled by the fur trading companies, had to pass through Minnesota on its journey north. Having a dependable postal service was vital to Minnesota's and the nation's economy and their political relations. Minnesota's youth and resourcefulness allowed for creation of a law impossible to imagine in older states. So what exactly did Minnesota's voting law say, and how did it work? At the legislative special session in the fall of 1862, Rufus J. Baldwin introduced in the House, and Francis R.E. Cornell ushered through the Senate, a bill which, on September 29, 1862, became an act to enable citizens of the state who are or may be engaged in the military or naval service of the United States to vote in the election districts where they reside at the general election to be held in the month of November 1862 and at all subsequent general elections during the continuance of the present war. The bill passed the House 30-6 and unanimously in the Senate. A few items to note from the title alone. The law extended to men in the Navy and had a sunset at the end of the war. Most states, if they eventually passed a law allowing soldiers to vote, neglected to include sailors. Iowa, which passed its law right before Minnesota, fell into this category. And while Minnesota's law set a precedent for how to structure absentee voting, the privilege only extended to the military and vanished in 1865. Section 1 of the Act laid out the qualifications of voters entitled to this privilege: that they be enlisted, eligible to vote, and a resident of the voting district for 10 days before enlisting. It then goes on to include anyone who is a resident of a voting district before enlisting and had since become a legal voter by virtue of age. The legal voting age was 21, and the age of enlistment was 18. So this could apply to large numbers of enlisted men. The few states that followed Minnesota's absentee voting model generally excluded anyone who became eligible after leaving the voting district. Connecticut, for example, required these men to return home on a furlough to vote. But as Minnesota had a statewide voter registration law since 1860, which provided for same-day registration, election judges easily incorporated these newly eligible voters into the electorate. Section 2 of the bill addressed how soldiers cast their ballots. The ballot could be printed or written, or partly printed and partly written. This wording mirrored the civilian election rules. Remembering that most voters came to the polls with a pre-printed ballot provided by one of the political parties, this provision allowed a voter to erase names from the pre-printed ballot and write in different ones. In other words, Minnesotans had the option of crossing party lines. The soldier then folded the ballot, inserted it into an envelope, and sealed it with wax. All the materials being provided at taxpayers' expense and carried by state commissioners dispatched for this purpose. Upon the envelope, the soldier wrote the address of the local post office in his home precinct, his name and unit, and acknowledged it to be his, quote, free and voluntary, unquote, vote. The soldier then presented the envelope with the ballot sealed inside to a commissioner who administered an oath to the soldier, requiring him to swear that he did indeed meet all the qualifications of a legal voter. Section 3 directed on the back of the envelope, the commissioner receiving the ballot had to fill in his own name, the date, the unit, the soldier's name, and certify the soldier's identity and free will in casting the ballot. Crucially, Section 3 ended with a note that, quote, his vote shall be received, notwithstanding he may have been challenged before the judges of election, unquote. This meant that once the soldier completed the voting process and sent the ballot home, there was no way to prevent his vote from being counted. In fact, Section 5 in the law, in directing the judges in how to make the voter registry ahead of the election, specifically states, quote, any absent elector whose vote shall be received by such judges, accompanied with the certificate of the oath provided by Section 3 of the Act, shall be inserted in said registry on the day of election, and such elector shall be allowed to vote, whether challenged under this act or not, unquote. Should subsequent investigating reveal illegal voting, Minnesota election law provided penalties for that. Section 4 says, quote, the person desiring to vote shall then deposit the said envelope, sealed, directed, endorsed, and certified as aforesaid, with said commissioners, who shall deposit the same with the postage prepaid in any post office, unquote. On the other end of the vote, the law states, quote, the judges, upon receiving the said envelope, shall keep the same unopened until the opening of the polls at the said election, when they shall examine the registry list of their district, and upon finding the name of the person endorsed upon such envelope on such registry list, they shall open the said envelope, and unless the person whose name is endorsed upon the envelope shall have died after certifying the same, shall deposit the ballot contained therein, unopened, in the proper box or boxes, and canvass the same with the other votes cast at such election, in no way distinguishing the same from the other votes cast, unquote. In this section, we can easily recognize the birth of familiar absentee voting process. The secrecy of the vote extended all the way from the voter's hand to the ballot box. While intermediaries may handle the envelope containing the ballot, at no time is the vote known to anyone except the elector. Section 8 of the Act imposed a felony, including prison time, for up to a year, and fines of at least $500 for anyone who tampered with a ballot in transit. In this way, the Minnesota law circumvented constitutional provisions that hampered other states' efforts to pass soldier voting laws. The idea that a vote would be cast in the district in which the elector resided, the center of Judge Woodward's decision in Pennsylvania, eliminated the possibility of voting outside the state. But Minnesota's law reinterpreted casting a ballot. the vote was cast not when leaving the voter's hand, but upon reaching the ballot box, envisioning a pipeline whereby a vote signed, sealed, and endorsed in one state was deposited unmolested in a ballot box in another state. A vote could be cast in the home election district, though actually voted hundreds of miles away. Also in this section, we see the creation of a paper trail to minimize potential fraud. With all the voting materials originating in the hands of a government-appointed commissioner, obtaining more than one ballot posed a challenge. But on the off chance that a soldier tried to vote more than once, his efforts would be thwarted back home, where the election judges had a registry of names, a stack of mailed ballots, and the discretion to accept only one vote per elector. For any ballots that arrived from soldiers whose names did not appear on the registry, there is a paper trail for that too. New York also tried to create a paper trail for its soldiers using proxy voting. Their soldiers named a person back home to cast the vote, then sent the ballot to that person, who in turn took the ballot to the polling place and deposited it. Not only did this create extra work for the soldiers, who had to grant the powers of attorney ahead of time, but the use of an intermediary masked ballot tampering. In fact, one of the few cases of voter fraud successfully prosecuted during the Civil War involved ballots heading for their proxies opened by Democratic operatives who swapped Democratic ballots for Republican ballots during the presidential election in 1864. Significantly, Minnesota's paper trail ended once a ballot reached the election judges. Most discussions of voting during the Civil War focused not on the methods used, but on the results. Were soldiers Democrats hoping for an end to the war, or Republicans fighting for the Union? Did they blindly support Lincoln as commander-in-chief, or did they prefer McClellan, a fellow soldier? Did their votes determine the results of the election? For states using the Pennsylvania election model, these effects could be easily known and indeed formed the basis of many lawsuits. In Minnesota, the law strictly forbade any system of knowing how the soldier voted. Their ballots were received, opened, and deposited without in any way being distinguished. And if their vote showed a preference or determined a race, we can't know. All we could possibly know is how many soldiers voted. By all accounts, soldier access to voting, as reflected in the number of votes received by the commissioners, was the largest failing of Minnesota's Soldier Voting Act. The original law provided for 3 sets of 2 commissioners each set containing a representative from each major political party. One set of commissioners stayed in Minnesota to collect the votes of soldiers within the state, while the other 2 sets divided up the rest of the country as directed by the law. With only a month between the passage of the law and the election, it is easy to see the challenges these commissioners faced. In fact, one of the only changes to the original bill as it made its way through the legislature was to move the election back from October to November in order to facilitate the commissioners' travels. Still, the time constraints left many soldiers unvisited, their votes uncollected. In response, in March of 1863, the legislature passed a resolution appointing 2 additional sets of commissioners to collect soldier votes. Even with 5 teams of commissioners, the following letter illustrates the frustration the commissioners felt. In a letter from Governor and former election commissioner Stephen Miller to Colonel William Marshall on November 12, 1864, quote, "I am terribly mortified that our brave men of the 2nd, 5th, 7th, 9th, and 10th regiments did not obtain an opportunity to vote. Assure them that I made every possible effort to reach them, both in Arkansas and Missouri, and that I will labor faithfully for such an amendment to the law during the next session as will reach every soldier belonging to the state in the future," unquote. Of course, by the election of 1865, Robert E. Lee had surrendered, marking the official end of the war, and with it, the end of the soldier voting law. So what is the legacy of the soldier voting law? By the end of the Civil War, most states had provided for soldiers to vote while on duty. Most of them followed the original Pennsylvania model, but 6, Connecticut, Illinois, New York, Pennsylvania, Rhode Island, and West Virginia, adopted laws similar to Minnesota. Like Minnesota, however, most states sunsetted their soldier voting laws when the Civil War ended. Not until the immense deployment of soldiers during the First World War did states revisit the need to allow soldiers to vote while deployed. Against this backdrop, in 1915, Josiah Benton wrote his crucial analysis of Civil War voting, titled "Voting in the Field." In it, he discusses Minnesota's law in a scant 6 pages, then dismissed it because the soldiers did not actually vote in the field, and no results of the votes existed. In 1902, in Australia, and in 1914, North Dakota, laws appeared that allowed for mail-in absentee voting. As the practice became entrenched and expanded after the war, few people remembered Minnesota's law of 1862. This lack of credit reflects several things: the unknown effect of the soldier vote on election outcomes, the relatively small number of soldiers serving from Minnesota, and the absence of controversy surrounding the law. As a general rule, the idea of soldiers voting did not become a partisan issue until 1863, after the Democrats made significant gains in Congress in 1862. By passing the law in 1862, Minnesota escaped the national political spotlight cast upon states like Indiana, Illinois, and Ohio. The question of the constitutionality of Minnesota's law arose as the bill progressed through the legislature. The House offered a motion to seek an opinion from the Supreme Court as to the constitutionality of the law, but that fell to defeat 16-3. The Senate sent the bill to its Judiciary Committee, but the head of that committee was the same Senator Cornell who introduced the bill to that legislative body. The bill breezed through committee. The only election whose results might have been contested on the basis of the soldier vote was the 2nd District congressional race between William J. Cullen and Ignatius Donnelly. Cullen, the Democrat, initially wanted to contest the result. However, contesting soldier voting became increasingly toxic for Democrats in Minnesota and nationwide by 1863. So he decided not to pursue the contest. With no constitutional or legal challenges, no contested elections, and broad-based bipartisan support for its precedent-setting law, Minnesota soldiers proved that secret ballots, absentee voting, and the post office could be integral parts of free, fair, and honest elections. In Ohio's case of Lehman versus McBride, the Supreme Court's decision in December of 1863 included the assertion, quote, "It must be conceded that in authorizing elections to be held outside of the state, it may be found difficult to protect the independence of voters, to scrutinize thoroughly the right of all who claim to be entitled to the elective franchise, to prevent frauds at elections and in the returns thereof, and preserve their purity by the infliction of penalties upon the perpetrators of fraudulent acts, and to surround the exercise of this important franchise with all the safeguards which might be thought advisable." Minnesota's Civil War soldier voting law clearly addressed these concerns and set an example for other states to follow.
Thank you, Rebecca. That was a very timely presentation given news that we've all had to endure for the last few months regarding some of these same very issues. It's really quite refreshing to know that Minnesota was at the forefront of the whole development of the absentee voting system and mail-in ballots. And some of those issues are still being contested now. We have time for probably one question. If anyone has a question, please unmute and ask Rebecca your question. We have about 5 minutes. Last call.
Yes, I do have a question. Rebecca told us that there were significant penalties or laws against cheating, etc. Do you know if there's ever been cases that were enacted where people were found guilty and penalized?
In the Civil War? Because
Or
Minnesota.
any time afterwards. Let's not the last 6 or 7 months, but before that.
Yeah, Minnesota usually has a 3 to 5, maybe 10 cases every year where there are contested cases, but it's really, really rare.